Here you go.
We are online and welcome back as we continue on our agenda of the North Dakota Ethics Commission. And we left it at ongoing business, item C. And Rebecca, are you going to handle this?
I apologize. Chair Lindquist, I'm going to handle a portion of this and then I'm going to hand it off if that's okay. So you'll see, first of all, I have that there's no formal motion that I am requesting or recommending for the commission, but we would appreciate, the staff would appreciate some really good direction on this issue as we move forward. So the agenda item is a memorandum that our previous chair, who has since passed away, Dave Anderson, that he requested our general counsel, Logan, that he complete. And the scope of this memorandum is, one, the commission's constitutional duties and authority, that we have a good understanding of that. And then two, this was shortly after Senate Bill 2004 was passed. And so he requested the impact of Senate Bill 2004 on the commission's internal processes and procedures in light of its constitutional duties and authorities. And then the last thing that Chair Anderson requested is to evaluate potential actions that the commission might take regarding either of those two things. Then Chair Anderson shared at the commission's May meeting that he did direct our council to draft a memorandum covering these issues. As we were preparing for the meeting, Chair Lindquist and I discussed this. She had me go back and review whether this was a formal motion. This was not. I didn't think it was, because I do remember Dave having this conversation with Logan, and that he simply informed the commission at the May meeting that he did this. So this was direction from the chair. This was not a formal request from the commission. So as we do, we start work on things. So our general counsel has started researching the issues presented that Chair Anderson asked in this memorandum. But as he has gotten into this, there have been some concerns that have arisen, particularly under the SAG agreement, the Special Assistant Attorney General provision. If the commission remembers correctly, there is a statute that makes, it's probably the incorrect word, the Attorney General the attorney for the commission. And Logan, as our general counsel, is appointed as a SAG under that authority. And so in the SAG agreement, that is a obligatory contract that Logan is required to enter into, he is required to produce any memorandum done for the commission to the Office of the Attorney General when it is a significant interpretation of any legal question. So given the dynamic and the public positions that our Attorney General, has taken, our general counsel has expressed concern regarding this memorandum and the requirements that he has under the contract, specifically depending on what he really determines needs to be included in this memorandum. It may be considered attorney work product, which is exempt from open record laws. Most of what Logan does produce as general counsel is an open record. This certainly may fall under the attorney-client work product, attorney work product, and therefore would be exempt from open records, but he would still maintain a contractual obligation to provide it to the Office of the Attorney General. This really puts our general counsel in a bit of a catch-22 because of his professional obligations under the professional rules of conduct to this commission as his client. And therefore, I am going to recommend that the commission essentially direct Logan as our general counsel to table the completion of this memorandum until we can evaluate the professional duties that he has in order to assess his professional obligations. This may be an extensive evaluation for him to do. That is what, as attorneys, we are required to do when we are put in a situation like this, that we need to evaluate and assess what our professional obligations are. And so I'm asking, this has been on our ongoing business for several months, and I'm asking that the commission table completion of this. Again, there was no motion, so we don't need a motion, but this certainly does put our general counsel in a very difficult position that we should not ask him to do. Do you want to provide anything further on that?
I guess I don't have much to add. You summed it up pretty accurately, not pretty. Well, I guess just as when Dave gave me this assignment, it's been an evolution of the relationship between the commission and the Attorney General's office, even in that short amount of time. Yes, there were things that happened prior to that, specifically in legislative session. But my concern, and there is layers to this, because you have, yes, if I prepare a document, it's an open record, potentially, unless it crosses the line into what is defined in the Century Code as attorney work product, which is different from the common nomenclature for attorneys when you prepare something for a private client. But attorney work product is defined in statute, and that material is exempt, meaning you don't have to provide it in response to open records requests, because it contains attorney impressions that may find themselves as issues in litigation or other adversarial proceedings. And the context of this memo, the direction that was given to me, is quite broad. My concern is if I start researching this issue and find something that I believe the commission should be briefed on that makes this memo become attorney work product, that we do not have to provide it because it may become an issue in litigation, what have you, under the statute. But I also have this now contractual obligation with the Attorney General's office that I would need to provide it to them, regardless of what the statute says, because that is in the SAG agreement. That was pretty much just part of my onboarding when I came on with the commission, that I signed this agreement. It's a standard practice when there is a special assistant attorney general in agencies and state government. So what I need to do is assess my professional obligations to the commission as my client when I have this contract out here with the Attorney General's office that is telling me to provide something to their office, when I guess the language is significant interpretations of legal questions. Well, that is also pretty broad, and that memo could cross the line into that, given the commission is a constitutional agency. There has been some adverse positions that we've taken, legal positions that we've taken that are adverse from what the Attorney General has presented through testimony, the Attorney General's office through testimony and through communications with the commission. So it's an issue that I need to address for my professional obligations, but also my duty to you as the client, but also my duty under this contract that I have with the Attorney General's office. It's a very complex situation.
Is there an ending point on that contract, or is it just open-ended?
It's open-ended to appoint me as the Special Assistant Attorney General to provide general counsel services to the commission. There's no end date written in the contract.
Okay. So that means you can terminate that at any time.
I'm not completely sure. I would need to look at the language that's in the contract regarding terminating it, but there may be ways to do that within the contract. I haven't looked at it through that lens yet. We're in the very early stages of analyzing this issue. I wanted to bring it to the commission's attention because you are my client and you asked for this. Well, Dave, when he was the chair, asked for this memo, and I need to provide that to you once we get these situations worked out, should you still request that.
Whether or not it is a motion, I move to table it until the commission takes it off the table.
All right, I'll second.
We have a motion on the floor. Any comments or questions? Read the roll, please.
Commissioner Sagsby,
Aye.
Commissioner Goodman,
Aye.
Vice Chair Kozer,
Aye.
and Chair Lindquist.
Aye. Okay. Moving on our agenda, item number 6, procurement of transcription services.
Cindy, I'm assuming you want me to take this one.
Yes, please.
Okay. So over the past year, actually over the past several years, the commission has used tools that we have easily and free at our disposal to make transcripts of hearings, interviews, or meetings. There have been instances that we have considered but not needed to hire a actual physical human transcriptionist, but we have never needed to based on agreements that we've been able to enter into with our witnesses in our investigations. But transcripts are a very effective and accurate recording, and it is mostly a verbal communication that we can then have in a written form. We did have some of the tasks that fell to our legislative intern was creating transcripts using AI tools. What we noticed in that process and what we noticed when we use what the Teams transcription services is it's very inaccurate. And so they can't be quoted. It's not something that we can use as a primary source when we cite things. If we do need to cite an interview, we are going back and we are transcribing that ourselves, either Logan in his capacity as general counsel or our operations administrator, whether it's Addie or previously Alicia. That takes a lot of time. That is one of the ways and one of the mechanisms for us to save time is to not do that anymore. So I would like the commission to consider whether we can enter into a contract for transcription services. There is no mandatory state contract for this. I did talk with procurement. There are several bidders. Many of them also provide general administrative services. There isn't anybody who specifically does transcription. They are usually individuals who also provide stapling, creating general, what I would call administrative type duties. And so those are the individuals that have the bids for the state. We can certainly, I plan on reaching out to several of those. There is only 3 that are local in North Dakota. All of the other ones are outside of North Dakota. But the other option, since we don't have a mandatory state contract, is that the commission can go out and we can enter into a contract with an online transcription service. So just based on the research that I've done, usually for an online platform, it is very cost effective. They bill at a minute by minute rate. So if you send them a 30-minute video, they bill based on the video length that they are reviewing and creating a transcript for. Many of those services use a combination of human and AI to create a transcript. They estimate, based on the independent analysis that I looked at, they are approximately 96 to 99% accurate. And so generally these online platforms are also have a quick turnaround time. They're either guaranteed in 1, 3, or 5 days, depending on which one you go with, which plan. And so based on this kind of increasing need as we conduct interviews, in particular with our complaints, and I know that we want transcriptions of different interactions, different verbal communication that is happening, I am requesting that the commission consider authorizing me to enter into a contract for a cost-effective and accurate platform. If you want me to come back with a specific entity, we can wait and do that next month. This is kind of the general information. This is the first time we've had this discussion, so I wanted to provide the general information. There are 2 online that are very accurate and have quite good reviews that are also specialized in government use, meaning that they have confidentiality requirements, et cetera. So they adhere to all of those. But basically that we be able to enter into that. I will need to touch base with NDIT. We'll have to notify them that we are doing that since it is an online platform or that it's an information technology request.
I'd make a motion to direct Executive Director Binstock to procure a transcription service subscription in accordance with procurement requirements.
I'll second.
We have a motion on the floor. Any further discussion or questions? Hearing none, call the roll, please.
Commissioner Stagsby,
Aye.
Commissioner Goodman,
Aye.
Vice Chair Kozer,
Aye.
and Chair Lindquist.
Aye. And we have discussed this a couple of times.
Yeah, I
From
think it's been kind of always in the background, but
yeah.
this is the first time we've raised it specifically.
And just as we've had these discussions about this type of service, it's related to not having enough staff and trying to keep caught up with our work. And as we mentioned it earlier on, not having the one set of minutes ready because we just, workload. But thank you much for the information and follow up. Moving on, update on process for appointment of commissioners.
Cindy, I'm assuming you want me to take this one too.
Yes, please.
So after the selecting committee, after their last meeting, several questions, and I'll hand it over to Murray to talk about those potentially, were sent out to all applicants who submitted their application to serve on the Ethics Commission. The responses to those questions were due back on September 2nd. By September 2nd, I did reach out to the governor's office. I reached out to their general counsel, Chris Joseph. He provided me with an update, and he said that by September 2nd, 2025, 2 out of the 39 applicants have since withdrawn their applications. So that's down to 37. And then out of those 37, 11 individuals did not provide a response. The responses to the questionnaire, I believe there was 7 questions or 8. Those responses were forwarded from the governor to Senator Hogan and Senator Hogue for their review. They are in the process of reviewing those. They have yet to set a meeting to review and then discuss. From there, they will move forward with interviews. So we will again keep getting updates from them. Murray is currently involved in the process, so he's probably our best resource for an update. And so
Rebecca.
Ward, although you expired 18 days ago, you're still on until you're off. So we appreciate that.
Rebecca, I think it would be good if you clarify for the public, because how you've reported this makes it sound like we, the commission, is doing this. And we're outside. We're outside the process. This is done through the governor's office. He's the lead for that application process, the review, those questions, all of that. And then it's the governor, majority leader, minority leader are the 3 people who review those applications and select or make the appointment.
Yep, that's correct. Yeah, the only thing that we do is I provide an update to you guys, and we are the ones that put out the call. Usually, I think we did it in a press release to let individuals know that the application process, but we do not have anything to do with the selection. In fact, we have gotten several open record requests for information related to this process, and we forward all of those on to the governor's office for their response. Anything else? Murray, maybe you want to.
I can comment because I was filling out a term, 1 year of a 4-year term. And so I went through the process 1 year ago. And if the process is similar, the 26 remaining on the list will be triaged down to about a half dozen based on the questions and answers. And then the governor, Senator Hogan will personally interview probably a half dozen individuals. And all of the applicants were to answer 8 questions. And I'll feel sorry for the three who are reviewing all of those questions because I had 8 questions and my answers were more than 8 pages long, single spaced. Because I wanted to try to answer as much as possible. And then when they have the interview process, they will be asking, from what I could tell, they're asking the same questions to all people interviewed, and they will rotate. The governor will ask one question, Senator Hogue will ask a question, Senator Hogan, then he'll go back and start again. And so they have been very thorough about it, and I think they're being very thorough again this year.
So we have no sense of timing.
None.
I think when Murray was appointed, you were appointed in late September. And we actually started the process later when Murray's round of appointment came in. So this one does seem to be taking longer. They are also attempting to fill 2 positions versus 1. That's a logistical consideration. Well, and 3, I guess Murray is. The commission, just to remind the commission, we did request that the governor, Senate Majority Leader, and Senate Minority reappoint Murray. We did make that request to them. But again, we don't make the decision.
And just make sure the public understands. So technically, we have 3 openings to be a member of the North Dakota Ethics Commission. We've requested for Murray Sagsveen to be reappointed, and then for those 2 vacancies to be filled, Mr. Kozer and then our former chair, Dave Anderson, which is the vacancy.
But they could fill 3. Yeah.
Yes, they could fill 3. But we're hoping.
Murray, did you have to go through all the questions again?
I will yes. And the questions were different this time than they were a year ago. And there were some interesting questions. I mean, thought-provoking questions like, how do you sense in a constitutional entity like the Ethics Commission will relate to the other constitutional entities like the governor and the executive branch and the legislative branch and the judicial branch, and it requires a certain amount of thought. A lot of thought. Yeah.
All right, moving on our agenda. Item number 8, discussion of First Amendment issues for political campaigns. Rebecca or Logan or who's?
Well, happy Constitution Day. I think that's why it's on the agenda today. As staff, I think we think this is an important discussion to have with the commission. It's an ongoing issue where individuals, particularly when it comes to campaign season, believe the commission should be somewhat of a clearinghouse for false statements and political advertisements. There's a lot of conversation about that when campaign season comes. So we wanted to have a public discussion about it, so the public is aware of how the commission handles these issues, given the state of the law in particularly the 8th Circuit. But there's a statute, it's North Dakota Century Code section 16.1-10-04, and that's entitled Publication of False Information in Political Advertisements. And it is a criminal statute that makes it a Class A misdemeanor for a person to, quote, knowingly or with reckless disregard for its truth or falsity to publish, and then it goes on, a political advertisement or news release, I'm not going to read the whole thing, but I'll summarize it, containing an assertion, representation, or statement of fact, including information concerning a candidate's prior public record, which is untrue, deceptive, or misleading, on behalf of or in opposition to any candidate for public office. And then it describes ballot measures, referred measures, constitutional measures, those as well are included, not just candidate campaigns, but then it lists the mediums that you can publish this information, and it could be a Class A misdemeanor under the statute. So that's an election-related statute. And as we know from Article 14, the commission has duties when it comes to elections. What that looks like is an ongoing conversation, but when complaints or issues come before the commission that would allege, for instance, hypothetically, this statute, the commission would be tasked with processing it. And one of those ways in which the commission can process it is the now discretionary criminal referral issue. So for the public's awareness, there used to be a statute that if the commission had a belief that a complaint contained information of criminal conduct, it was mandatory for the commission to refer that matter to law enforcement. During the 2025 session, the legislature did make that discretionary. So now the commission has the discretion of whether it will refer a matter. So the commission has adopted the standard practice that if this statute would come before it in a complaint, that the commission would decline to use its discretionary power to refer that to law enforcement and would instead direct that individual, the complainant, directly to law enforcement if they believe that the statute has been violated. And the reasoning for that is an Eighth Circuit case, 281 Care Committee versus Arneson. It's a 2014 case from the Eighth Circuit Court of Appeals, and that analyzed a Minnesota statute that is very parallel to the current statute in North Dakota regarding false information in campaign materials. And in that case, the Eighth Circuit held Minnesota statute is unconstitutional for violating the First Amendment. It triggered in First Amendment law, there's layers of what the court calls scrutiny levels that apply to First Amendment and speech. You have rational basis, intermediate, and then strict scrutiny. For political speech, they always apply strict scrutiny. So the court applied that. With strict scrutiny, you need this is taking me back to law school. It's very fitting that we're in the law school for this discussion. You need a compelling government interest that's narrowly tailored to the purpose the law is serving. So the court went through that analysis and it said, quote, "It is not necessary, is simultaneously overbroad and under-inclusive, and is not the least restrictive means of achieving any stated goal," unquote. And the court really, in that opinion, favored counter speech. Let's say you're one candidate and you have an opponent and you believe your opponent is lying about you. The court, they didn't directly say it, but they alluded that the proper remedy is to say in your own campaign material that the speech that is being brought against me is a lie. Counter speech is the answer, according to the court. There's another quote in there that I'll read. It says, quote, "The citizenry, not the government, should be the monitor of falseness in the political arena." And that comes from that same opinion. So again, after reviewing that opinion, it's binding to some extent. Again, keep in mind they were analyzing a Minnesota statute, but the commission, we had concerns given that precedent, given the statute in North Dakota, that if the commission would be reviewing these matters and referring them to law enforcement, even just being a participant in that process could involve the commission potentially in litigation regarding the constitutionality of that statute. So that's why the commission has taken the direction that if you believe this is a criminal matter, it's a violation of a criminal statute, you need to go to law enforcement on this issue. We won't process it. We won't use our referral mechanism to process those complaints, those issues that come before it. So you can take it directly to law enforcement. Any questions on that part? Because there's another piece to this that I'd like to bring to the commission's attention.
Before we go to the next issue, can we just talk about what the commission's doing right now? Right now, the commission, if legislator A files a complaint saying legislator B or candidate B lied about me, and it comes in the form of a complaint, the practice has been to dismiss it because of the court ruling, right?
Correct. Yes.
So why couldn't the commission consider the complaint, and instead of treating it as a criminal issue, treat it as a civil issue as to investigate whether it indeed was a lie. And if it's a lie, you treat it and say more of a fact-checking thing, because then you can give to the voting public, this is the truth and this is the untruth. Should that be the role of the Ethics Commission, to help the voting public sort out deliberate misstatements? You see where I'm going here?
Mhm.
Because you're not conflicting with the court ruling, because they're saying the criminal, if it's a criminal statute, that is unconstitutional. But if the Ethics Commission is just fact-checking, saying what the truth is and what the untruth is, would that conflict with the court ruling?
So he asked two different questions there. Do you want to answer the first one before you get to the second one about why don't we do that now?
Okay, yeah. So why we don't do that now? The way the statute is set up, it's strictly a criminal issue. So let's take any other criminal issue that we come before the commission. Let's say, I don't know, what have you? Bribery. That comes before the commission. The commission does make a criminal referral on it. This is a hypothetical. So it goes to the state's attorney with jurisdiction. Let's assume they prosecute the matter. There's a guilty conviction. Then it comes back to the commission after law enforcement proceedings. The prosecution is over. The commission then can, based on that criminal conviction, take notice of what the court did and find that as an ethical violation. The commission has done that in the past. The way this statute is set up, we have concerns from the get-go of, well, you're referring it. We don't really want to be involved in that process, given it's solely a criminal issue. There's no civil component to it. There's no, that's a good example of that.
So there's no corresponding civil action or civil recourse. It's only a criminal recourse that is available in this context. So if there were a ethics rule or another state statute that allowed for a civil type investigation or enforcement mechanism, then we could investigate it or run through the process potentially.
So that's the question. Can the commission do that then if there is a civil counterpart to it? There was in Minnesota, actually. The way the Minnesota statute was set up, they would file a complaint and it would go to their Office of Administrative Hearings for a civil investigation, and then there was fines, I believe, that were associated with that. Now, it's an issue in that opinion from the court, but their analysis isn't focused solely on that. They've taken the criminal piece as well. But there is some language in that opinion that even putting somebody through the process of having that complaint filed against them where they have to respond to it on the civil side, that it could be, they basically say it's unconstitutional on that grounds as well.
So if you're just fact-checking, that may be unconstitutional.
It could be,
Could be.
yes.
It would have to pass strict scrutiny.
It would have to pass. It depends. Giving you the lawyerly answer. If that issue is the sole issue before the court, I think it likely wouldn't be good for the commission if that's how it was set up.
The reason that I ask the question is that voters should be entitled to factual information. And if a candidate is deliberately providing untrue information, it's altering the process, and counter speak may, it devolves sometimes into he said, she said, or just two candidates arguing with each other. And should the Ethics Commission have a role in that to determine what the truth is? And I'm just asking the question.
I'm not sure I would advise it. Is it something to explore potentially? Maybe. to do that analysis, but what I'm seeing from the court in that opinion is the answer to them is counter speech, and government doesn't have a role when it comes to campaign materials. Now, when it comes to election administration and people putting out fraudulent materials, like, I don't know, go vote, go register here, and it's a fraudulent link or something like that, the court has a different opinion when it comes to those issues because it interacts with somebody's actual right to vote, not just choose a candidate and decide the issues. So it's tricky. It's difficult when people come to you and as the commission and say, well, I think candidate A or B is lying. What can the commission do about it? And the Eighth Circuit essentially says, well, the answer isn't the commission, it's your political campaign. You need to go out and respond to it because that's counter speech. That's what the court believes is the correct solution. So that's kind of what you're left with. Now this is my analysis of the opinion, but that's what I'm reading from the Eighth Circuit.
You answered my question
So
generally.
during the last primary season, we had a number of complaints that had this legal pattern in it. And without talking specifically about complaints, this was a legal issue that was raised a number of times. And I know in the office, I would throw up my hands and say, this seems exactly like Murray is thinking. It seems wrong that the voters are not getting accurate information. And so I said, Logan, what can we do? And he's like, well, we really can't do anything. I'm like, I don't like that answer.
Well, that's not
But
100%
it's
true.
not
There's
100% true.
Second piece to this.
But let's talk about the second
Move on
piece.
to the-
Yes, I want to introduce
Patty,
the
can you
second
bring
piece.
up that attachment? So
It
yeah,
depends,
we're
yeah.
gonna move out of the Eighth Circuit. Let's go to a different jurisdiction. We're gonna go to Miami-Dade County in Florida, actually. So this is how they handle this issue. There's a county ordinance that I want to look at it before I speak here. So what the county ordinance provides is an opt-in to a voluntary, what they call a voluntary statement of fair campaign practices, which Addie just put on the screen. And what this is it's an ordinance that allows candidates for office in this county to waive their First Amendment right and abide by their ethics commission, the county ethics commission's jurisdiction when it comes to these types of issues. So if you look at the first page here, they outline the county ordinance, and voluntary is italicized and bolded very heavily throughout, but they also capitalize and make sure the reader knows that this is a declaration and First Amendment waiver. So you are waiving your constitutional rights by opting into this provision. They put instructions on there. Addie, can you go to page 2? And then if you look at page 2, they have 11 criteria that by signing this and waiving your First Amendment right, you agree to abide by, including number 11, I will not use or permit the use of campaign material that falsifies, distorts, or misrepresents facts. So if a candidate signs this, and there's been some discussion, I think Kogel has materials where they've discussed this waiver, where candidates feel pressured to sign this, like, oh, I'm signing it, my opponent should too. So then you are, what Kogel, the people described it during this roundtable is, well, you are essentially
I'm sorry, I missed that. What did you?
they say the people who sign this are essentially inviting complaints against themselves by signing this because it opens up 11 other doors for a complaint to be filed against you. But there is some, what they alluded to, there's some pressure in the county for people to sign it if their opponent does. But then they can have complaints filed against them for those 11 things because they have now waived their First Amendment right. And the commission will come in and investigate those issues based on this contractual agreement, this waiver. And then the commission, because the First Amendment's kind of off the table at that point, they've waived that right. the commission can say, yes, this was a lie because they agreed to abide by our jurisdiction to determine whether it was a lie. So that's how one jurisdiction is handling this issue. I'm not saying it's the answer. I just wanted to present it to the commission for a discussion because I think it's interesting.
Well, that's if it's a blanket waiver. You know, if they sign this, it'd be a blanket waiver. Couldn't there be a stipulation in whatever they're signing that it only applies to this particular situation or this particular complaint?
Perhaps the way their form's set up is based on the county ordinance that they have. So it's pretty general in nature. That's why it's in this form. But if they change their county ordinance, yeah, I think they could do that. Specify which issues it covers in more detail.
Well, we can do things better in Florida.
Well, and I was curious, Logan, when did they implement this and have they gotten takers?
I think I don't know the exact year. It's been some time. And 2010.
It was revised in
That was
2010.
yeah, it's been over a decade at least.
And then I'd also like, oh, I got to check this out because I'd like to know the backstory. Why did they do this? What happened? And maybe that's a conversation at Kogel.
It might be. I was going to go back and look who presented this information because I think it was somebody who worked for the county for some time, and he didn't seem to be a big believer in this process.
And then Murray, because before we convened today, I asked Murray to tell me what this is in plain English. And tell the public what you told me, please. Okay, because I wanted affirmation that how I read this was what I think and how I know things without being a lawyer.
I agree that I'm not going to lie, and if I do lie, you have jurisdiction over me. That's about as simple as I could put it. That close?
That's all I should have said.
But it's an interesting option because I believe that the voting public should have facts, and there's a lot of disinformation in the system now. Some of it generated outside state too.
And this is one mechanism or creative way that they have found to get at that issue, right? Without violating the First Amendment. Also, I just want to point out that there is a specific section or session on the First Amendment and political advertisements at Kogel that we will be attending. It's an hour-and-a-half session on things like this. Sorry, I didn't mean to interrupt.
Can we keep these issues on the agenda? Keep talking.
Well, and I think that's why it's on our agenda now.
Mm.
And again, it's kind of come to us as the North Dakota Ethics Commission in different ways as we, particularly this past legislative session, and some of the complaints that have come in. And that, and when I talked to the lawyers about this, it was like, oh, why is it us? Why is it the Ethics Commission? And shouldn't these other bodies from where these complaints come in, why don't they have the checks and balances? Or why don't they define or determine what that is? Because some of this, it's very subjective.
Mm-hmm.
And how, but then once you do this, the legal stuff is like, here it is, and you got to live with it. But oh no, oops, wait, we didn't think of this or that situation when this was passed, and that's part of what we're grappling with as a, I guess, a toddler ethics commission body in our growth and development in 5-6 years. So, but It's a good analysis, and I'm glad you brought this forward to us because it's timely and topical.
So Cindy, you asked the question about why this comes to us. It comes to us because individuals, particularly candidates, get put in a situation where something goes out there and it is materially misinformation or is factually extremely inaccurate. There was particularly an uptick in this sort of political activity during the primary season. We saw a significant change, I would say, from what has been present in North Dakota elections prior to 2024. And that's not my impression. I mean, it's my general impression anecdotally, but there are other individuals who have told or shared that they feel as though it's just changed how campaigning happens, feels different, excuse me. And the reason that it comes to us is because this is a criminal statute. And so otherwise they would go to the sheriff, and on the priority list of what the sheriff cares about or should care about, this is really at the bottom of the list because of all the other things that our sheriff and our state's attorneys are trying to work through. They're also backlogged. They have, much more dire situations than a political lie that happened in an advertisement. And so that is why we have become, as Logan said, the clearinghouse for these sorts of complaints. And when you read it and you read the materials, sometimes Logan and I are able to quickly go and see, yes, this was not an accurate statement. You can check the legislative history. Sometimes it is, very clear. Other times it's more subjective. But the reason that we're talking about this is because there does seem to be a change in North Dakota, and what can we do as a commission to potentially address that?
Or what can't we do?
Or can't we do? Yes.
Well, and I want to make a comment, very personal comment on the counter here on the Minnesota case. That last thing about the citizenry, not the government, should be the monitor of falseness in the political arena. And I've read this a couple of times in my preparation for today's meeting. I'm like, well, there's an aspect to what I know now as a member of this body of the commission. And that statement to me is like, well, this is why the commission was established.
It was in the language of the Constitution, Cindy.
Yeah, it's because the citizens wanted a vehicle, a place, that, and then all these layers and pieces and details, though, they get caught up in different ways. So it's like,
I guess to that point, Cindy, I would just add this is focused on false issues, not just information in general about people's interests or the other things the commission processes as well. So I'll leave it at that.
all right, thank you. Any other comments? All right, we can move on. Item 9, discussion of rules related to Ethics Commission organizational structure. Rebecca?
Okay, so does everybody have for this one? I want to make sure that everybody has attachment 10, which is an annotated, or I would call it highlighted version of the Ethics Commission's policies and procedures. So over the past, I believe it was since the end of 2022, I do think that there were policies and procedures in place before the end of 2022, but those just did not get put in writing many times, unfortunately. Now we do have them in writing. We update our policies and procedures manual on a regular basis. I feel like last month we just adopted another interim policy and procedure. And in a meeting just a few weeks ago, Commissioner Sogsveen suggested to both myself and to Logan that the commission consider moving many of or some of its policies and procedures that really relate to core operations and structures out of our policies and procedures and into formal rule. So go through the formal rulemaking process, put them in ethics rules instead of having them in our policies and procedures. So based on that suggestion, I think Murray was working through some of these as well. What we did is we simply walked through our multi-page. There is a lot of policies and procedures that we do follow. And took that and highlighted the ones that really relate to operations and structure, and that the commission can consider putting into ethics rules. What are excluded from the policies and procedures that the commission may want to move into rule are things such as our distracted driving policy, our policy review, our risk management, which are specifically directed, that OMB specifically directs the commission adopt a policy. So for all of the ones that are not highlighted, the commission has the ability to either adopt a policy on its own as directed through OMB, or the commission has adopted the policy that is similar to something that OMB has put out on its own. For instance, our overtime and compensatory time policies, our bonus structure policies, a lot of the HR audit type internal workings are not included as those things that should be moved to our ethics rules. But I'd like the commission to consider, for instance, moving our commissioner pay policy. That's always been in policy. We've followed this policy since November 30th of 2022, which is when it was approved and adopted, moving that into an ethics rule. The request for advisory opinions. This is what we've included here in this policy and procedure is actually language that we attempted to have put into a statute, into the advisory opinion statute. That did not, that was not successful. And so moving this into an ethics commission rule, this really outlines a process that we already follow. And then we have our internal code of ethics policy that we shall do things. And so I want the commission to consider, and if it would then like us to draft a, depending on the discussion, we could draft a proposal for you that does include this. For instance, I just want to point out another one is the commissioner term policy, what that looks like, the election of the vice chair and the chair, computing time, which relates to complaints, which easily, what was that? And we're already adding that. That's right. It's in the policies and procedures though, because we have not added it yet. But we adopted that one because we knew that it was missing. And so there are some things that we should consider adding in rule instead of in policy. I did just want to note this is a common practice for other ethics commissions. I specifically included in your memo the link to the New Mexico State Ethics Commission rules that they adopt that relate to their operations and procedures. And so they did that. They went ahead and did it in rule as well. And so I just wanted to bring that, and Murray can probably speak more on it as well.
So for 50 years or more, I have worked with governmental agencies and nonprofit organizations. And what struck me is that the organizational structure of the Ethics Commission is remarkably scant. The ethics constitutional amendment basically says there shall be an ethics commission and the commissioners shall serve a term of 4 years. And then the implementing statute 5466 adds a few more sentences. You shall stagger the terms and so on. But it's remarkably thin. So For example, when we got to the end of September, the question was, is our term over? Because my appointment says I'm appointed through August. Well, what happens if I haven't been replaced and or my term extended? And there really wasn't a rule on that issue. That's why we quickly passed at August 27 a policy extending it. So I think that there should be some basic rules in place that really say this is what the commission is and this is how we operate, and things that should be in the rule. Now, for example, I do bylaws all the time for a nonprofit organization. The bylaws say this is how you operate an organization, but we don't have any of that in rule. And so I'm suggesting that we have rules to supplement the Constitution and the statutes to fill in the blanks. That's all I'm suggesting.
Okay. As a non-lawyer, help me understand. So we've put it in policy. Why would we change to rule? What's the difference?
I'll defer to the general counsel to talk about the difference between a rule and
Thank
a
you.
policy.
So a policy is kind of just a statement. This is what we follow. It is more akin to bylaws, but the rules, they are law. When the commission goes through the rulemaking process, you're making law. So if you put it in the rule, it has in the hierarchy of procedures and laws and all that, it's upping it a step essentially by putting it in rule. It's just moving it up. It has a little more authoritative than just a policy.
Okay, thank you. And, I know we've had this conversation a couple of different times in different ways. So, yeah. And I appreciate the way you've presented it to us, particularly because as I've looked at it, I'm like, okay, yeah, I get it why these ones are highlighted. So, okay. But I'm curious for my colleagues, should we act on this now? I'm curious, and why I'm asking this about should we act on this issue now, because of the issue of terms and these pending vacancies and where we're at and what we're trying to do and get done.
I propose the policy about vacancies in August so that there's something in place. And with a policy, you can change it every meeting. With a rule, you propose it, it goes out, it's a public hearing, people can comment on it, and then it becomes more fixed in place.
Yeah. And how long, as Rebecca, remind me, or Logan, about how long does it take us? So like if we were to pass this today, yes, we want to put these into rule. How many steps, or what are the steps?
So we have to start with the note. We have to get it in the format to publish it, do the full and abbreviated notice, then go through, set the hearing. So then you go through the comment period. Consider the comments. You can respond to them directly, but you have to consider them. And then you can adopt the final rule. Altogether, it's about 4 or 5 months, and that's as short as it can be, I believe. The other consideration too is if you want to move it into rule, but there's another rule you want to adopt or amend, you can include it in the next round of rules as well.
Mm-hmm.
So it could go out in the same notice. It doesn't have to stand alone either.
Okay, commissioners, what do we want to do?
Well, I think we should get them in rules. And I think that we should start now. it may take time, but it's not that difficult to do. So I'm going to move that we change the policies we have in, do I want to call it attachment 10?
Yeah, yes, you can, Ron.
Okay, that we have in attachment 10, we move those policies into rules as the highlighted portions, that we don't have to do anything about the other stuff. Just the stuff that applies to us, that we move them into rules as the procedure as we want to say, as we have to proceed procedurally. I don't know, that's not very good.
Start the rulemaking process
Right.
for these particular, to move these policies and procedures, the highlighted ones, into rule.
That's what I said, yeah.
Okay.
I'll second.
We have a motion and a second. Further questions or discussion?
I have a question. Is there anything else that the commission thinks should be included in this group of rules? And it's something we can talk about as we move through the process too, but
I prepared a list of things but I didn't bring it along with me.
Mm-hmm. Did you give us that list, Murray, or do you? Okay, I think I have it somewhere on my desk somewhere.
we'll look for it and we'll include it as a,
'Cause it'll come back to us
yeah,
before.
it'll be a draft version
Draft,
before
okay,
we
yeah.
do the notice piece.
Okay. Does the
Did-
motion have to be amended?
no.
No, what I'll do is I'll prepare it as highlighted and then we'll have those other issues ready for the commission to discuss then if you want to include them.
The other thing that we can do is we can review what New Mexico included in their rule about their operations and their structure. And we can see if any of those make sense to add because they're also a constitutional entity.
All right. Further questions or discussion? Read the roll, please.
Commissioner Stagsby,
Aye.
Commissioner Goodman,
Aye.
Vice Chair Kozer,
Aye.
and Chair Lindquist.
Aye. Motion carries. Oh, staff, more work.
It's all right.
Okay. And we are now at item 9.5, where we would love to have a conversation discussion with our audience and not just law students, but who's ever here, including, I think, is there a vehicle online for people to put questions into the chat? I don't know. We haven't done this before, so.
We haven't turned. Yeah.
Yeah, I think for our meetings, our protocol is to disable the chat. So I don't think there is that option, unfortunately, for those online.
Okay. So the public who are online, we apologize. The tech capabilities aren't there for you to put questions in the chat or online. And we do have a few people here in our audience, and I know there's a student who would like to ask us questions, a couple of students.
One moment. We have microphones in the front.
Yeah, can y'all hear me?
That's better.
So, we were discussing false political advertisements today and how that's a big, serious problem. And I was just wondering what y'all's thoughts are on big tech censorship, because if the remedy is going to be counter speech, it's a big problem if giant corporations are limiting the speech of people, like on our Facebook or Twitter, and whatnot. Like, I'm just curious what y'all's thoughts are. Okay. Oh, I'm sorry. So we're talking about false political advertisements, and that's a big problem. And the court held that counter speech is the remedy. So where does big tech censorship fall into that? Like, what do y'all think about that issue? Because how can we have counter speech if people's views are being silenced on the biggest, the town center, basically?
So what you're asking is how, correct me if I'm wrong, but how does the commission approach the issue, or what their thoughts are about when people are trying to get campaign materials out and they're using technology platforms, I'm assuming social media, and there's censored or the post is taken down for whatever reason? How does the commission approach that issue? But also when the solution, what we've talked about, for people to just respond to it, how can you respond to it if technology companies are taking it down, essentially?
Exactly.
They're looking at me, so I don't know if they want me to answer the question or not. I guess from my perspective as the commission's counsel, that triggers a different issue because the commission is a government entity. So when we look at government censorship of speech, that's different from private companies and private corporations when you abide by a term of agreement to whatever their parameters are to engage in that platform. Sure. So the question was, well, how do you deal with those issues when government is essentially censoring those people by coordinating with technology companies? And I think that's more of a policy question, so I will leave that to the commissioners to answer. Thank you for the question. Yes. Ron, your mic's off.
A comment on Matthew's question. The problem that we have and other entities have is the type of speech you're talking about is generated, and then commissions like us or other people can respond to it, but we and other entities are overwhelmed once it happens. You know, especially with big organizations, it comes out and it's disseminated. People respond to it privately, in that they say, well, I don't like that. But when the solution is arrived at by our commission, as an example, it's 3, 4, 5 months beyond when the speech was attacked or when the speech was given. So by the time we respond to it, it's almost too late. Do you understand what I'm saying? You know, and I'm not offering a solution because I don't have a solution to that. You know, we can fix some things, but not everything. And that's one thing that we would have difficulty with, just because of the time element of how we can respond to it. Murray, do you have any comment on that?
I think I've said enough today.
Okay. It's Ward and I have to talk now.
I agree with Ron.
Well, and I'm going to just comment that as a young law student, getting ready to graduate here soon, I would really value your input as a young person and then as a young lawyer who sees and understands that particular issue and topic and where it's at. Because even though it's like just that thing, it's not, because it has tentacles and rippling and that. But somebody's got to stand their ground and make a statement or resolve it or solutions. And so I'm hopeful as a young student about to graduate in law that help us figure this out.
So for the public record, Eric Murphy, North Dakota House representing District 43, south of the tracks in Grand Forks here. And so I appreciate the commission coming to Grand Forks and giving an opportunity for law students to interact and listen to and begin to think in their minds and deal and wrestle with some issues that are not open-ended. I will quote a Robert Earl Keen song, "Live by white and by dark and, black and white, but you die by shades of gray." And the problem with ethics is it's always a shade of gray. There is no overt answer. Oftentimes it's super easy, right? It's not white, it's black. There's a tremendous amount of gray. And so I thank the students for coming so they begin to understand what the commissioners wrestle with. I would like to focus on briefly with regards to campaigns and free speech. Since politics has started in the United States, we've never had clean campaigns, right? And people do exaggerate, and people do sometimes cross some lines that shouldn't be crossed. The question is, and while I would agree that the electorate should perhaps have some appropriate information, the question is the commission the arbiter of that? And I think that's an important consideration. Council presented the Miami-Dade County pledge policy, not as a suggestion, but just to show what's being done out there. And my question is, why would I want to sign that? And then I say something that is 100% factual, but my opponent doesn't like it. So now we open a can of worms where they say, well, see, and then we let it up to, in athletics, you tell players, never put it in the officials' hands. Okay. And so as a candidate, I'd be putting something in the commission's hands. And so then it's the lens that the commission looks at it. So while I think this is important, I think the reason the House, at least when we voted on this, it was to try to put people back in as a threat, that there's some kind of threat if you do go way out of bounds. I personally don't campaign that way. I don't intend on campaigning that way, especially since the minority leader is my neighbor. But I think it's important, and I think we can see in North Dakota, in the last election, we had a lot of things that were being said that, were half truths, perhaps out of context, but were really not factual. And this is where I think as a candidate, you need to have your own moral compass on this and where you're going to go. And I'm not sure that you're the arbiter of that. So those are my comments. I look forward to making some comments electronically on some of the rule changes. I appreciate Commissioner Sagseen's comments. I think there's a lot of big issues that you're wrestling with to try to find the right way. And I know sometimes the legislature and the ethics commission don't see eye to eye, but at the end of the day, you have a very important job to do. And I appreciate the fact that each of you have taken time to serve on this commission, and appreciate your wrestling of issues as they come forward. And frankly, you're sort of finding your way. And I think the chairwoman made that comment. You are, in a way, finding your way as we move forward. So thank you for your service. Those are my comments, and I appreciate your time.
Representative Murray, I want to thank you also for being here and spending the afternoon with us. It's like, whoa, all right. Because you got to really hear our issues and our discourse and what we're grappling with, because we would like you as an elected official to help us. You know, what are the solutions? Where is that common ground and who should be doing what where? And it's only by having this exchange, you know, that you know and understand kind of where we're at, you know, and that. So, but I'm really appreciative on behalf of the commission and our staff that you're here. We did send out the invitation to all the local.
Yeah.
And we know it's a Wednesday afternoon and people work, family, all that. But I'm very grateful that you took the time to be with us.
But my newest colleague, Representative McNally, was here but had to go to teach a class. And so I don't have a class to teach today. So I appreciate his being here as well.
Exposed to 3 hours of excitement.
Sitting on appropriations, I've been seeing a lot of excitement.
Any other comments or questions from the audience? Okay, hearing none, we will move on our agenda.
Cindy, I think what we could do is if there are, I think there's a class that's done in just a little bit here, or maybe was just wrapped up 3 minutes ago. Is that correct, timing wise?
Take a 5-minute break.
So if we could either take a 5-minute break if students file in, or we could go into executive session. And then if there are students who have questions afterwards, we could open it up again if you would want to.
Okay. Commissioners, what should we do?
I think we should go into executive session.
Okay, I'm hearing 5-minute break.
Okay, fine.
On this side, they said 5-minute break. So yeah, let's take a 5-minute break. And when we reconvene, we will be going into executive session. And I have a whole page to read for that. Thank you all for being here and participating. We are back in session for the North Dakota Ethics Commission at approximately 3:40 p.m. Wednesday, September 17th. The next item in the agenda is complaint numbers 23-011, 23-013, 23-014, 24-08, 24-013, 24-015, 24-026, 24-030, 24-031, 24-032, 24-033, 24-035, 24-041, 25-004, 25-021, 25-022, 25-038, 25-039, 25-040, 25-047, 25-048, 25-049, 25-050, 25-051, 052, 053, 054, 055, 056, 57, 058, 059, 060, 061, and 25-062. These items must be discussed in an executive session. The legal authority for closing this portion of the meeting is North Dakota Century Code sections 54-66-12 subsection 1, 54-66-12 subsection 3, and 44-04-19.2 subsection 1. The topic or purpose of this executive session is discussion on complaints. Information regarding the content and parties to an Ethics Commission complaint is confidential. As a complaint must be discussed in executive session, no motion is needed to enter executive session. The exec session will be recorded, and all members of the governing body are reminded to limit their discussion during the exec session to the announced topic. Any collective decision, collective commitment, or other final action by the governing body must occur after it reconvenes in an open meeting. The prohibition on taking final action during the executive session does not apply to approving guidance or instructions to our attorney. We will now ask members of the public who are attending the meeting to leave the meeting. We anticipate adjourning the executive session and reconvening in the open portion of the meeting at approximately 4:05 p.m. The minutes will show that the executive session began at approximately 3:45 p.m. and was attended by Commissioner Goodman, Commissioner Sagsveen, Commissioner Kozel, Commissioner Lindquist, executive staff, Binstock, Carpenter, and Addie. And Addie, I'm sorry, I forgot your last name. Oops. Once an executive session, roll call will be taken and announce everyone present on the recording. The minutes will show that the executive committee session was adjourned at approximately 4:10 p.m. and the public has been invited to return to the meeting. We are now back in open session. At this time, I will entertain any motions.
I move to direct Executive Director Binstock to act as directed during executive session on complaint numbers 25-060, 25-061, 25-062, and 24-008.
Any questions or comments? Call the roll, please.
Commissioner Sagsbing,
Aye.
Commissioner Goodman, Vice Chair Kozer, and Chair Lindquist.
Aye. Motion carries. Further business. Oh, okay.
I would like to request in October another face-to-face meeting, hoping that it will be with the new commissioners having an opportunity face-to-face. And it doesn't necessarily need to be in Bismarck. It can be someplace else, but that's the chair's call. But
Meeting date is October 15th. Right. Meeting date is October 15th for the commission's
October
information.
15th in person. I agree. I really like being in person. And I have no preference. I like that y'all came to Grand Forks. Made it convenient for me. But any preference on where we should convene? And I'm going to suggest we do go to Bismarck. Well, because it's centrally located, but should we have new members? Can we be optimistic that it might be a better location for onboarding or orientation?
Probably before.
And the other thing is that we have an open invitation to the governor to attend the meeting too.
All right. Anything else? Or both? Okay.
We'll get the logistics squared away for getting you guys there in person.
Anything else? Good day, good meeting. I will adjourn the North Dakota Ethics Commission.